everyone, I'm Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about what happens when your disabled child turns 18 and what you need to do beforehand. Now, when your child is under the age of 18, you as their parent can make most, if not all, of their decisions on their behalf. However, when your child turns 18, the law views them as an adult, and you no longer have the ability to control what and how decisions are made or even receive relevant information about those decisions. Now, for most parents, this is a rite of passage. They just have to sit back and watch their children leave the nest and begin their adult lives. But what if you don't have a child, or what if you have a child who's disabled? That child may need help making financial or medical decisions. And what will happen to them if you can't just step in and help them with this, if they still need your support? The first thing you want to have your child do is sign a financial and a medical power of attorney. A financial power of attorney authorizes someone chosen by your child to make financial decisions for them if they're unconscious or too ill to make or communicate the decisions about themselves or otherwise just unavailable to do so. And without these important documents, you could end up going to court to be granted the authority to handle your child's financial affairs. And although your child may designate you to act on their behalf, they're still able to make their own decisions, so long as they can maintain the ability to do so. A medical power of attorney allows your child to name a trusted agent who can make medical decisions on their behalf if they cannot make them for themselves or they're unable to communicate their wishes to the relevant healthcare providers. This person is required to the greatest extent possible to make the decisions that your child would have made had they been able to communicate those wishes. So long as your child is able to make and communicate their own medical decisions, they're allowed to do so. You would only be asked to step in the event that they are unable to make or communicate their wishes themselves. Now, while both of these documents will go a long way in helping you to continue providing for your child once they turn 18, your child has to have the required mental capacity to execute the documents. The specific requirements for determining capacity vary from state to state. It's important to note that your child's inability to physically sign the documents does not automatically disqualify them from being able to put the documents in place. Now, although your child may be able to make some decisions for themselves today, if they have a degenerative condition, you don't want to wait until it's too late to have these documents prepared. As mentioned previously, these documents are meant to help your child when they're unable to make decisions for themselves. Your child will continue to maintain the right and the autonomy to make their own decisions until they're unable to do so. If your child cannot execute the necessary documents, or if your decisions have to be made on your child's behalf and your child does not have the mental capacity to execute a financial or a medical power of attorney, the court will have to get involved. This can be very lengthy, costly, and a public process. Though the court proceedings to establish guardianship and conservatorship, you'll need to request that the court grant you the authority to make decisions on your child's behalf. The exact name of the roles for which you may be seeking appointment vary from state to state, but generally the guardian, sometimes referred to as the guardian of the person or a conservator of the person, is an individual who is authorized to make general life decisions on your child's behalf. These decisions may include things such as where your child lives and what type of medical treatment they will receive. The conservator is sometimes referred to as a guardian of the estate or guardian of the property or conservator of the estate, is the person who's authorized to make all the financial decisions on behalf of your child. Now, as opposed to an agent under a financial or a medical power of attorney, if you're appointed as a guardian or conservator, you have authority to make all of the decisions, and your child ceases to be able to make any decisions for themselves. For some disabled children whose ability to make decisions is greatly impaired, this may not be a problem. But for others, this approach may be too far-reaching. In some states, you may you may have the option to seek a limited or a partial guardianship or conservatorship. In this case, you can only make decisions that are specified by a court order. For all other matters, your child retains the right to make his or her own decisions. The overall objective of the court is to promote independence for your child. So if you have a disabled child who is approaching their 18th birthday, now is the time to start planning for their future. We are here to assist you and your child to take the steps needed to ensure that they are well taken care of as adults, just as they were when they were children. I'm Kelly Longtin from Kelly Longtin Law, and I hope you found this beneficial. And I hope if you have a disabled child that you get these documents in place as soon as possible so you don't run into any obstacles along the way.